Hi, I'm Phil Zimmerly at Bose McKinney Evans, and as a business, you may be having interns come to join your program. Do you need to pay them to comply with federal law? Answering that question depends on whether you're a nonprofit business or a for-profit business. If you're nonprofit, you likely don't need to pay them so long as they're working for you voluntarily and with no expectation of compensation. If you are a for-profit business, the analysis is a bit more complicated. And courts will look to a 7-factor test that looks at who is the primary beneficiary of the relationship. Is the business the primary beneficiary of the services that are being provided by the intern, or is the intern the primary beneficiary of receiving an educational experience as being a part of your business? In making that determination, the court will look to 7 different factors. In the first factor, a court would look to the party's expectation about compensation. Do they have an understanding at the outset of the relationship as to whether or not the internship will be paid or unpaid? It's very important that an intern have that understanding at the outset of the relationship. The second factor looks to the extent that the training that's being provided to them as a part of your internship is similar to that at an educational institution. If they're receiving the same sort of training that they would receive at their college or at their high school, it looks more like an educational program than actual work for your business. Third, a court would look to the extent that the internship is tied to a formal academic program. For example, if the intern is receiving academic school credit for being a part of the internship, it's more likely that they do not need to be paid. Fourth, does the internship accommodate the intern's academic school year? Now, during the summer, that seems to be a pretty easy analysis because you're providing the internship during the time between their spring term and their fall term. Fifth, is the internship limited to the period of time that provides the intern with beneficial learning? The sixth factor looks to whether or not the work that's being provided by the intern displaces or complements the work that's being provided by your full-time or part-time employees. If they're doing the same type of work that's regularly performed by your employees, it's more likely that they should be paid as employees rather than treated as interns. The seventh factor looks to whether there's an expectation as to whether the internship will lead to full-time employment. Now, this makes sense because a court does not want a business to use the internship as a training period where they should be otherwise treating the intern as an employee during that training period. None of the 7 factors are dispositive. Ultimately, it's a flexible test where the court is going to look to who is the primary beneficiary of the relationship. Is it the business or is it the intern? Now, in making that determination, it's very important that the business make the correct determination, because if they fail to do so, they can face significant liability and damages for failing to pay minimum wage and overtime. I'm Phil Zimmerly. Thanks for watching.